I'll talk to one microphone and then you can put it over there.
State of Wisconsin versus Dylan Campbell, 20 CS 1414. Please.
State of Pierce by Assistant District Attorney Carl Hayes. Good afternoon.
Mr. Campbell, welcome. Glad to have you here today, sir, and welcome to both of the attorneys. Counsel both, what is it you wish done in this case today?
That the defendant will today enter a plea of guilty to count 2.
Okay, I'm hearing you say a plea of guilty to count number 2. Count number 1, what would happen to that?
I would move the court to dismiss but read in count 1 for purposes of sentencing.
And were there any discussions about what would occur after a finding of guilt?
Yes, sir. If the court should accept the state's motion to dismiss but read in count 1, and if the court should accept the defendant's plea of guilty as to count 2, the state would recommend 18 months of confinement followed by 2.5 years of extended supervision to be served consecutive to any other sentence.
Defense to be free to argue? Yeah. Mr. Voss, is that an accurate statement then? Yeah. All right, Mr. Campbell, I'm going to begin by granting the motion that's a part of the plea discussion in order that count number 1, second-degree recklessly endangering safety, is ordered dismissed. That charge will be read in and considered for sentencing, but in all other respects, it's dismissed. You understand that? Yes, sir. Now, before I can ask you what your plea is to count number 2, battery by a prisoner, I'm required to review some matters with you. First, the maximum penalties if you're found guilty on count 2 would be a fine of up to $10,000 and/or total sentence of up to 6 years between extended supervision and initial confinement. You understand that?
Yes, sir.
Next, the burden is on the state to prove each of the elements of the crime of battery by a prisoner. And these elements, I need to be assured that you know them. First, the state must establish that you were confined in a state detention facility. You understand that?
Yes, sir.
Thereafter, the state must show that you intentionally caused bodily harm to PXK. You understand that?
Yes, sir.
Third, the state must establish that PXK was another inmate of that state institution. You understand that?
Yes, sir.
The fourth element is that you caused bodily harm without the consent of DXK. You understand that element?
Yes, sir.
And the final element is that you knew that DXK was another inmate, and you knew that DXK did not consent to your causing bodily harm to him. You understand that element?
Yes, sir.
All right, we've gone through the elements and the maximum penalty. I now do ask you the single charge of battery by a prisoner. What is your plea?
Guilty.
Are the facts as stated in the underlying criminal complaint accurate?
Yes, sir.
Is anyone forcing you or making you plead guilty to this single charge?
No, sir.
When you enter this plea, you give up your right to some very important and fundamental constitutional rights. You have a right to a jury trial where the verdict or decision by the jury must be unanimous. You're giving up that right. You understand that?
Yes, sir.
Now, you have a right to remain silent, and no adverse inference can occur as a result of exercising that right. But even if you remain silent in the word trial, you can call witnesses if you want it, and your attorney will have a right to cross-examine anyone who testifies against you. You're giving up these rights. You understand that?
Yes, sir.
Finally, the burden is on the state to prove if they can your guilt to this charge beyond a reasonable doubt. Now, in this case, you've told me you're guilty, and you've told me that the facts in the underlying criminal complaint are correct and true. That would provide a basis for me to conclude beyond a reasonable doubt that you're guilty. Do you understand that?
Yes, sir.
Knowing that you still wish to continue with your plea of guilty to this one charge.
Yes, yes, sir.
Now, on your behalf, counsel has submitted a plea questionnaire and waiver of rights form as well as an addendum. They report to have your signature dated today. Did you sign them?
Yes, sir.
Is the data that's been written into these forms true?
Yes, sir.
For instance, sir, it says that you are 19 years old. Is that true?
Yes, sir.
It also indicates that you have completed the 10th grade in school. Is that correct?
Yes, sir.
Have you understood fully everything that's occurred here in your case this afternoon?
Yes, sir.
The report also indicates that you're currently receiving treatment for a mental illness or disorder. Is that true?
Yes, sir.
What is the diagnosis or the term for that mental illness or disorder?
I think it's like intermediate social disorder, ADHD.
And as a result of that, it indicates also that you have, in the last 24 hours, had certain medication. And then the geodome and aceraline.
That's the name.
Are those two medicines that you took today?
Well, Geodol, I take it at night, and especially I took it this morning.
And do those medicines, when you take them, help you to get through each day on a day-to-day basis?
Yes, sir.
And again, have you fully understood everything that's occurred here in your case this afternoon?
Yes, sir.
Next to the attorneys, District Attorney, anything more you want in the record before I make a finding on the plea entered?
Judge, I would just ask that the record reflect that the state is in compliance with our victim requirements. We did send notice of the date and nature of today's proceedings to the victim, in this case, Mr. Kong. Mr. Kong is apparently electing not to submit anything for the court's review or make any claim for restitution.
The record can reflect the state is in full compliance with its obligations to notify the victim. Mr. Voss, is there anything more you want in the record before I make a finding here?
No.
All right, Mr. Campbell, based on the entire record before us, I make two separate findings. First, I find that your plea of guilty to this single charge is a plea that you've entered freely, knowingly, and voluntarily.
Yes, sir.
Next, based on the entire record, not just your plea of guilty, but the entire record, I do find that your guilt on that charge has been established beyond a reasonable doubt, and therefore I do find that you are guilty in count 2 of battery by a prisoner as charged. I'm now going to look to the clerk and get a tentative date and time for sentencing, since only the plea was going to occur today. Madam.
August 27th.
That works for the state.
What about 2:00 p.m.?
Yes.
What was the time again?
Yes.
Thank you.
Next court date will be August 27th at 2 p.m. for sentencing.
Mr. Campbell, between now and the time we come back on the 27th of August, we'll closely with your attorney, Mr. Voss, and we'll see you back at that time of sentencing.
Yes, sir.
Good luck to you, sir.
Okay.
Boy, how's that for Judge Hampshire? We got them all set up for,
For 3, right?
oh,
All right, on.
the staff did a great job.
Mr. Evans, can you hear me?